Joining us now remotely for trends in hotel receiverships is Alissa Nann. She's of counsel with Foley and Lardner. She's a member of the Bankruptcy and Business Reorganizations practice there, and she's selected by the Dragon as one of the 500 leading U.S. bankruptcy and restructuring lawyers, and she's also recognized as a super lawyer and New York Rising Stars list. Ladies and gentlemen, please welcome Alissa.
Hi, Steve. Can you hear me?
We can hear you just fine, Alissa. Welcome.
Great. And do I need to share my screen with everybody on the slides, or do you have them there?
I think you need to share them.
Okay. Let me do that. Sorry, give me 1 second.
Take your time.
Well, as I'm waiting for this to open, I could just introduce myself briefly, and apologies that I'm not there. I'm actually in Tampa, Florida right now. My son's on spring break, so we're in Florida. So you guys gave me a reason to visit the Tampa office today, which I had not, of Foley, which I had not been to. So thank you for that. And as Steve said in his intro, I'm a bankruptcy and restructuring attorney. I'll call myself a hospitality dabbler. I represent all kinds of fiduciaries in bankruptcy, in receivership, et cetera. So I've been doing more of that work recently as receiverships have gotten a lot busier. Let me just see if is this working, Steve? Can you see my screen?
It is working. We see your screen. If you could just click on slideshow.
Yeah.
Top left, and then we should be all good to go.
Okay. Did that work?
Not quite yet.
Hey, Alissa, can you
Yes.
share from your desktop and not PowerPoint directly, and then just go into PowerPoint?
I will try. So the format they set me up here on multiple screens, and I can see what I'm looking at, but I can't see what you guys are looking at.
Sure. Alissa, we're going to try on our end too to go ahead and bring it up. Yeah,
Sorry about that.
No, it's quite all right. We're running into a little capacity issue.
So yeah, so I guess I can just go ahead.
Yeah.
My apologies.
That's all right. Go ahead. We got you
okay.
right now. Why don't you just go ahead with that? It's good.
Sure. Okay. So hi, everybody. Sorry about that. So, interestingly, I took this topic and I sort of gave it a bankruptcy and restructuring spin. And so what I kind of wanted to focus on, and I know it seems like everybody's been saying, there are apologies for talking about COVID over and over again, but obviously, given COVID and given all the shutdown orders, as a restructuring attorney, since 2020, we were expecting to see a lot of bankruptcies, particularly in the hospitality space, with stay-at-home orders and the like, and restaurants, as David was just talking about. What we actually saw was a lot more bankruptcies in the retail space, mostly with businesses that had issues sort of pre-pandemic related to, retail issues, and not so much bankruptcies in the hospitality space, particularly with hotels, which is interesting. And instead, what we've seen is an uptick in receiverships, which compared to bankruptcies can be a lot faster, a lot cheaper, and a lot more flexible. a receivership can be a helpful tool, particularly for a lender to get control of a property pending foreclosure, to do things like put in new management, address performance issues, and possibly sell the property through a court fiduciary. What we've really seen it being used as a tool to do by lenders is to put pressure on the borrowers to find new sources of financing or come up with proposals to address deficiencies and really put their money where their mouth is, frankly. And so I like to think of advantages, I like to think of receiverships more as a lender tool and bankruptcies more as a borrower tool. And the biggest advantages of a receivership over a bankruptcy are control for a lender, speed and cost. So kind of just at a high level, usually the loan documents will provide that if there's a default on the mortgage, the lender can seek appointment of a receiver. The loan documents will provide for that. So that's not anything extra that the lender typically needs to do. And courts will typically enforce those loan documents and appoint a receiver if there is a default that exists. And frankly, often the borrower will consent unless they're contesting the default. So it's a pretty, unlike filing for bankruptcy, which, can sometimes be, particularly if a lender is trying to put a borrower under bankruptcy, that can be, and it's an involuntary, that can be a difficult process. So this is usually a lot more streamlined because it's already provided for as a default remedy. And also too, sometimes the borrower and lender can negotiate a receivership order in advance of filing. So the entire filing is consensual. The receivership powers are laid out in the receivership order that the borrower has already signed off to. And if it is consensual, sometimes a court won't even require a hearing to approve the appointment of the receiver, although that'll vary from court to court. Another advantage for lenders is they typically have a lot of influence over the selection of the receiver. If they've got a consensual negotiated receivership order and the receiver who has been accepted by the borrower meets any requirements of the court, depending on the jurisdiction, that person is usually appointed as the receiver. Although again, that depends from court to court and jurisdiction to jurisdiction. A lot of courts like to appoint their local guys and gals if they have them, but just depends. So with less hearings in general, the appointment process being pretty easy and streamlined, particularly if it's consensual, and just generally as the case goes on, there's typically less reasons for hearings. There's less reasons for motions. Often you'll have a receiver appointed, and other than filing his or her monthly or quarterly receivership reports, there may not be a ton of activity in the case, just pending the foreclosure on the property going into REO, if that's what happens. There was a recent decision too, just an added bonus for receivership and protection of the actions that they can take in a receivership case. There was case law out of the Third Circuit in 2021 that upheld a decision finding that receivers are entitled to quasi-judicial immunity, and that they deserve immunity for their actions that are taken within the authority of the court, which includes any actions that they take based on authority granted to them in the receivership order. And the receivership order, I call it the Bible. We try to put the kitchen sink in there of the receiver can do anything and anything and everything necessary to run the hotel. So sometimes to sell property, depending on whether that's allowed under the state laws, hire people, fire people, enter into contracts, get rid of existing contracts. So they've got a lot of discretion in the receivership order already. And so now the Supreme Court denied cert to take that Third Circuit case up. And so that's good law, at least for that jurisdiction. So that's another added protection to receivers and the actions that they can take in the context of the case. Alternatively, filing for bankruptcy, like I said, I like to look at that as more of a borrower tool as opposed to a lender side tool. A borrower can file a voluntary petition to stop a foreclosure proceeding once the lender initiates it. A lender also has the option to file an involuntary proceeding against a borrower, but it's a lot more complicated. There's statutory requirements they need to make depending on the amount of the debt. They may need other creditors to join with them to pursue an involuntary filing against a borrower. So it can be a little more complicated. And bankruptcy cases in general will require more court hearings. As an initial matter, the borrower's got to disclose a lot of information, whether it's on the first day of the filing or very shortly thereafter. There's a whole series of schedules and statements that have to be disclosed with all of their liabilities, debts, which can be expensive and timely to prepare. Often they need to, in addition to counsel, they may need to hire financial advisors or things like that, depending on the case and the plan for a restructuring or a liquidation. Also a consideration for lenders is there may be, there's often a creditors committee, which is looking for ways to monetize the debtor's assets, to make payments to unsecured creditors, and just another constituency to sort of, stick their hand out and say, me too, which you don't really have in receiverships. And another consideration is just the bankruptcy sale process. If the ultimate goal is for a lender to sell the property, receivership can be a much more streamlined way to do that without a lot of court oversight necessarily, and other constituencies to consider. In a bankruptcy sale process, I mentioned a creditors committee. There can also be a DIP lender that's brought in to provide financing to the borrower during the pendency of the bankruptcy case. That new money is usually used to fund operations during the case and not to take out the existing debt, although depending on the size of the DIP loan, it can be used for that purpose, in addition to funding operations. But what that means is the DIP lender gets priming liens and basically has the ability to control timing of things, including a sale process, set certain milestones, et cetera. So as an existing lender, if you don't provide the DIP, you kind of then are playing second fiddle and subject to the whims and the milestones that are instituted by any DIP lender that will come into the case. If you are looking to sell a property through a receivership, alternatively, you're not going to have that, and you can kind of control the timing of the process. Also in a bankruptcy, it's also possible for a case to be converted to a Chapter 7, which means a Chapter 7 trustee would be appointed and would take over the property to liquidate it. A receiver obviously is appointed to run the property while the debtor and the borrower and the lender try to come to terms or sell the property or decide whatever they're going to do with it. So something to consider. But a consideration for lenders to think about, particularly now that there's still so much money floating around out there and there's so much M&A activity in the hotel space, is just to be mindful of financing options that may be available to borrowers, and that a borrower can use the bankruptcy process to try to wrest control away from an existing lender. And use that process to cram down a plan or a sale or something that would be the borrower's preference, as opposed to letting a lender put it into a receivership and either sell it through that process or go into REO. And so, basically with all, there's a lot of funding and financing that's been out there. And so we're seeing, an uptick in receiverships. I think for that reason that it's a way for, if a borrower doesn't want to play ball, it's a way for the lender to really force the borrower into a decision. And really what we've been seeing is a lot of cases that are getting teed up for receivership and then are either dismissed very quickly thereafter because the borrower has come up with new funds and is able to refinance and take out the existing lender. So we're really only in for, a matter of weeks or sometimes months. Or what we've seen a lot more of recently are, we're getting ready, we're teeing up this receivership, it's going to file, and then, all of a sudden we're in talks, and we get everything prepared, and then we don't actually need to file because a deal has been able to be worked out in advance of the filing. So it's been an interesting time where, the expectation that there'd be a lot of bankruptcies, those didn't really materialize necessarily. A lot of receiverships are happening, but I think a lot more, there's a conversation, it's being used as a tool and a pressure point by lenders to, either get taken out or to get borrowers to agree to things that they didn't necessarily, want to agree to. And that being said, with the uptick in receiverships, there is a need for skilled receivers. Hotels are different than other commercial real estate. I mean, everybody there knows that better than anybody else. They have very unique characteristics, 24/7 operations, rents resetting daily. They're subject to all kinds of agreements like franchise and management agreements, sometimes union collective bargaining agreements. So if the receiver doesn't understand the unique characteristics of the hotel, they're going to have potentially a hard time acting as a receiver. And interestingly, in a lot of states, there aren't that many requirements for a receiver. There are some states that require training and registration of a receiver, but that's sort of rare. You don't necessarily have to be you don't have to be an attorney. You don't necessarily have to have a certain professional degree. You just have to, in most states, be able to disclose that you don't have an active conflict. So it's a relatively low bar in terms of degree or qualification requirements. However, if you go into a court and try to have a receiver appointed who has nothing to do with the hospitality industry and has no experience, that's going to be tough. But that being said, there is a need for skilled receivers in this specific industry, where people who know this industry versus folks who've just acted as receivers and are qualified as receivers or registered as receivers in their state for regular, commercial real estate or other types of assets that don't have these quirks to them like hotels do. We've also seen some activity in the hotel management space of certain hotel management companies kind of getting more into receiverships. And just, it's kind of a sign of the times that this is a big, there's a lot of activity there, and we expect to see more activity sort of as funds start to dry up. I think this is going to be, a very active space, and I think an alternative to bankruptcy that a lot of lenders are going to want to use as a tool in a slightly different way than they're using them now. And I know we were running a little bit short on time. So the last thing that I wanted to raise was just about unions and collective bargaining agreements in general. With a lot of hotels being closed during COVID, it's actually been interesting that sometimes it's been cheaper to just keep the hotel closed and try to work out a sale while the hotel's closed, rather than getting it to be reopened if there is a strong CBA in place. I always preface anything to do with unions by saying you should consult a labor and employment attorney before you make any decisions about what to do based on a CBA. But we have had some cases where if there are ways to operate the hotel with a non-union skeleton staff, something that can be done if necessary. There was an interesting case in Chicago recently where a receiver was appointed to two separate hotels. One was a union hotel and one was a non-union hotel. And the union was trying to argue that the CBA that governed one of the hotels basically somehow should then be implicated with respect to the other hotel, because it was the same receiver running the properties, that was ultimately settled. So no case law out of that issue, but depending on the jurisdiction and the CBA and the aggressiveness of the union, they're really trying to obviously enforce the CBAs as much as possible, prevent hotels from reopening with any, non-union employees, regardless of whether the CBA allows same. So it's another hot topic now as travel's back, things are up and running. A lot of hotels that were previously closed are reopening. That's a big consideration as well. So I know that I am at my time, so I will open it up for questions. And again, apologies for the technical issues.
Oh, thanks. Thanks, Alissa. That was terrific. We've got a question right here. 1 second.
Hi, I was just wondering if you could let me know how many creditors you need for an involuntary bankruptcy and what the time frame is.
So it depends on the size of the debt. I don't have the numbers in front of me. It's in the bankruptcy code. It's it's 3 if it's a certain amount. I can actually, and I don't know what happened to my screen, Steve, but all I can see right now is myself. So I'm really having a problem. But if I can get the name of the person asking the question, I am happy to send you a reference to the code.
Okay, it's Heather Lacey, and it's hlacey@legalseafoods.com.
Oh, sure.
You guys actually
Yeah.
worked for us.
Yes.
And it was not a receivership, but it was
Right.
another interesting transaction.
Yeah, I work with Katie like every day.
Oh, yeah, she's great.
Yeah,
Please tell her hello.
I
and
will.
Paul. Thank you.
Yes, of course.
Alissa, so I just quick question on the receivership use as leverage. Is it because the power then lies in the lender so much on the receivership side? Is that why the leverage is so great and it just forces the borrower to come to terms or do something that they otherwise wouldn't?
So it's an interesting question, Stephen. And I think that's right. I mean, I think, the lender starts the foreclosure process, right? I mean, that's
Yep.
the first step. And then appointment of a receiver is part of that process. So if the borrower, they're in foreclosure, I mean, if the borrower has a legitimate basis to contest a default, that's one thing, right? And they can contest appointment of a receiver as well. But once a receiver is appointed, they're kind of out. I mean, they're not controlling the hotel, they're not controlling the operations, they're not controlling anything that happens, and it's all part of a path to a sale or REO. So, all of the control has been taken away from the borrower at that point. I mean, they're the owner in name still, but I think it's a big step. The initiation of the foreclosureship itself is the first step, but the appointment of a receiver is the second big step. And that's really the step that takes away any control that the borrower has over the property. And, that's a big deal. So I think a lot of borrowers, it's kind of their come to Jesus, right? Of like, you're no longer running this property. Your people now work for us, if that's what, the receiver chooses, and give us your keys, give us all your passcodes, give us everything to run the hotel, and you're out. So I think that's a really, a strong tool in terms of a rude awakening, whatever you want to call it, that sometimes make borrowers, change their mind about things or find money or whatever the case may be.
And it just drains more money, right? Because somebody's got to pay the receiver, right? It's got to come out of the
Yes.
of the operation.
It's an added
right? So
expense.
more-
Exactly.
Yes,
Exactly. It's
right,
coming
yeah.
off the top of operations. Exactly.
That's right.
Pay the receiver and the receiver's management team, which may be more expensive than the management team that was already in place.
Yeah, we see that. Yes, we see that. Alissa, I think we're out of time, but thank you very much for joining us.
Thank
we
you so
really
much.
appreciate it. Yeah.
Thanks,
we hope to see
everybody.
you again soon.
Take care.
Yeah, bye-bye.